That's what I mean. So for those who do not know me, I'm Nikos Lavranos. I'm the Secretary General of EFILA, and I very warmly welcome you to the 10th EFILA annual lecture, which is, of course, a great achievement. And over the years, please take a seat. Over the years, we had many famous and outstanding speakers, and Martina will be introduced in a minute, so I will not take too much time. But first, I will give the floor to our host, Professor Lucas Mistelis, who will say a few words, and then we will hear the welcoming address from Jose Angel Rueda, who is the chairman of the executive board of EFILA. So without much further ado, Professor Mistelis, please.
Thank you, Nikos. I would like to keep the introduction very, very brief. Queen Mary and EFILA go back for quite a number of years. From the very beginning, when EFILA was constituted, I was invited to join the advisory board of EFILA at the time. At these critical times, of course, all discussions got about TTIP. Who talks about TTIP these days? And of course, despite all of this discussion about legitimacy crisis, actually the first annual EFILA lecture was scheduled to take place in Brussels, but moved in London because of a terrorist attack in Brussels. And the first annual conference of EFILA, we'll talk about conference later, was in London at Senate House, and there were protests outside Senate House because, again, it was TTIP time. Now, looking sort of at the topic of today's speaker, and of course, the fact that a lot of that sort of has been slowing down or calming down, or whatever you want to do that. I think what we have tried to do throughout all events that EFILA has organized, some of them at Queen Mary, is to facilitate debate, hear from different voices, hear different views, and effectively investment arbitration and indeed investment is a product of state policy, state treaties, and within that framework we operate. So I am delighted to welcome you back to Queen Mary after last year's lecture. There's no pressure on the lecture, but I think the majority of the lectures have been nominated for Best Lecture of the Year, and we have a couple of wins as well. So no pressure on the lecture at all. But the topic is certainly one that is outstanding, and the experience of the speaker, who will be introduced briefly by Jose Angel, outstanding. So we are just delighted to play this facilitative role yet again, and I would like to invite Jose Angel Rueda, who is the chair of the executive board of EFILA, to give what we used to call the State of the Union address of sorts, and also introduce the speaker. Jose Angel.
So, good evening, ladies and gentlemen. Please be most welcome to this annual conference hosted by EFILA. As chairman of the executive board of EFILA, I would like to also to thank the sponsors of this event, our friends from Control Risks and Walters Kluwer, represented tonight or this evening by Akash Brahmachari and Jael Hollander. Akash will moderate the Q&A session with Martina after the lecture, and subsequently, Jael will make a presentation on Kluwer's arbitration tool. And of course, I also want to thank Queen Mary University of London for hosting us this evening. Lucas omitted the fact that he himself was a previous executive member and chairman of the executive board of EFILA. The annual lecture is for EFILA an important event, one of the two main events that we organize every year. And we take them very seriously since their inception, and we spend time on exploring the best candidates at all times to make a high-level speech in order to offer the arbitral community the best lesson for international arbitration practitioners and scholars that very frequently extend as shockwaves throughout the arbitral community. I insist, and I hope that your lecture today becomes well nominated and perhaps it can be awarded any award from Global Arbitration Review in the future. This year we had no doubts about who should be our guest today. Last July, Martina Polasek was elected as the new Secretary General of the International Center for Settlement of Investment Disputes, ICSID. By far, ICSID is the most important institution for the investment arbitration system and plays a fundamental role in assisting disputing parties to settle their differences by peaceful means. Martina holds degrees from the George Washington University Law School, the University of Paris 5, René Descartes, and the University of Gothenburg in Sweden. She has been working for ICSID since 2001, and it is not easy to find any other person in the world with so much experience in high-stake investment arbitration proceedings. As you can see on the screens, the title of a lecture is Reflections on the Past and Future Significance of ICSID's First 1,000 Cases. The time in which ICSID was barely known has long elapsed, and I can tell you when I started my PhD doctorate in 2004, people were not very much aware of ICSID. But now ICSID is at the very forefront of the international arbitration system. Many things have changed in the world since the Washington Convention establishing ICSID was signed in 1965. And next year, the Center will mark its 60th anniversary with the endorsement of having a record 158 contracting states of the convention. Over the years, ICSID has not escaped challenges, and in 2002, as probably you all know, the Center reacted to these challenges by approving an ambitious set of new rules that provide unparalleled transparency to its proceedings and even contemplate that regional economic integration organizations, REIOs, be disputing parties in arbitrations administered by the Center outside the convention. That is true. This was inconceivable 60 years ago, but it is clear that ICSID has adapted itself to the changing circumstances of foreign investments. And I would like to finish this address by reading one passage of a book on ICSID arbitration, and perhaps it could sound familiar to you. It says, I quote, "The convention has sometimes been regarded as an instrument for the protection of private foreign investment. This characterization is one-sided and too narrow. The purpose of the convention is to promote private foreign investment by improving the investment climate for investors and host states alike. The drafters have taken great care to make it a balanced instrument serving the interests of host states as well as investors." It is likely that it sounded familiar to you as written today. However, perhaps you could be surprised or even shocked if I tell you that I got them from the lecture given by Dr. Aaron Broges, the first Secretary General of ICSID, before the Hague Academy of International Law in 1972. Even though more than 50 years have passed since they were delivered by Martina's predecessor, they are perfectly valid to sustain ICSID's existence as well as to address certain comments and the need of the investor-state dispute resolution system. Whether ICSID will reach the 2000 administered case and when belongs obviously to the future. Martina, as I said before, I'm sorry for my Czech, Děkuji a vítejte. The floor is yours. Thank you very much.
Thank you so much, Jose Aguirre, for that nice welcome. And thank you so much to EFILA, in particular to Nikos, Tatiana, to Lucas, for inviting me to this year's lecture. As Jose Aguirre mentioned, I have been at ICSID for a very long time. I started in 2001. And so I started when I was a junior lawyer and sort of worked myself up the trenches. And I think that my election as Secretary General is really a testament to the whole ICSID team for its internal expertise. That's how many of us are. We have been there a long period of time and know the ICSID process inside out. And that is always helpful. Now, I do note the aspirations for today's lecture. I'm not sure, my aspiration was to send short waves into the arbitration community, but I will do my best to at least do a good lecture. Now, on August 8, 2024, ICSID registered its 1,000th case under the ICSID Convention and Additional Facility. Now, this was a big milestone and an opportunity to reflect really on the development of ICSID case law and what it has meant for the advancement of the rule of law and in the field of international investment and procedure. What are the lessons learned from these cases and what do they tell us about the future? The first observation that I would like to make is that investor-state dispute settlement, ISDS, and especially based on investment treaties, is still a young and evolving discipline. It may not seem so to some of you who have practiced in this field for a very long time, but consider the landscape and the demography of ICSID cases. When I started in 2001, ICSID had only registered roughly 85 cases over the span of 35 years from its establishment. The first ICSID case was registered in 1972, the 500th in 2015. Although the number of cases has become a steady 50 to 60 cases a year, it still means that we have registered more than half of our cases in the past 15 years or 10, yeah. Almost 300 of them are still pending. Second, the basis for consent and the applicable law on the merits have multiplied over the time. At the time that ICSID Convention was drafted, investment contracts dominated the landscape of foreign direct investment. In fact, the first investment treaty came into force in 1962, the Pakistan-Germany BIT. And the first 18 cases up until SPP versus Egypt in 1984 were based on investment contracts. In total, we have registered 832 treaty cases based on 320 different bilateral investment treaties and 30 multilateral treaties. Adding to that picture, which may be surprising, according to data from UNCTAD, treaties that were concluded before 2000 account for 97% of all cases to date. Now, third, there has been an increase in ICSID member states over the years. Up until 2001, only 55 had been involved in cases. And now we see a much broader spread. States from all regions of the world act as parties to ICSID cases. In total, 139 states and 1 regional economic integration organization. We also see an increasing diversity in the nationality of investors, including nationals of capital importing states. There's no longer this paradigm between capital exporting and capital importing. We have seen an increase in south-to-south disputes, but also north-to-north disputes. And this is partly due to the global rise in foreign direct investment and partly to an increase in investment treaties, laws, and contracts. And inevitably, it's not surprising that with more cross-border transactions, there are more disputes. And the more nationalities involved, the more diverse the universe of the treaties and laws applied. Fourth, we also see a broader universe of economic sectors involved and new subject matters of dispute. By the 1000 case, there were numerous different economic activities subject to disputes in 11 different economic sectors. And fifth, the majority of decisions and awards have been issued in recent years. When I joined ICSID, we knew all the ICSID awards really well. At the time, we only had 37 awards. Now, in the last fiscal year only, we rendered 46 awards. From all 523 awards rendered in ICSID cases up until August 8, about a quarter were rendered since 2021, and 72% were rendered since 2011. 381 of them were on the merits, with roughly 80% based on treaties and the rest based on contracts and domestic investment laws. Now, it should be noted that only 2/3 of ICSID cases have led to awards, and the remainder has been either settled or discontinued. Overall, historically, you have seen a fairly balanced outcome when it comes to the awards between investors and states. Including the 108 awards that declined jurisdiction or found that the claim was manifestly without legal merit, the rate is roughly 49% in favor of investors and 51% in favor of a state. Now, counting only the awards that were decided on the merits, the rate is roughly 60 to 64% in favor of the investors since 2011. In sum, this massive growth in ICSID's case law started less than 25 years ago. The cases involve a growing number of different treaties, now at 350. There is a broadening pool of users and economic activities involved, and the large majority of awards has been issued within the past 15 years. It is still a young discipline, and it will keep evolving, and we will see pretty much the same picture going forward. While there are changing trends in disputes under treaties and changing trends in the treaties of how they're being negotiated and concluded, and there are some terminations of treaties, UNCTAD predicts that there will continue to be disputes under older generation treaties in the next 10 to 15 years. And at the same time, we will likely see more cases under newer regional treaties and FTAs, for instance, the ASEAN, the CPTPP. We will also likely see more investors from emerging economies in Asia, for instance, and more South-South and North-North disputes. We will also likely see an increasing number of cases related to the energy transition and other climate change policies. Now, at the same time as investments in the green energy sector grow, the number and proportion of these arbitrations has grown considerably and will continue to grow. Now, some growing pain in this development is part of the process, but the good news is, and that leads me to my second remark, that investor-state dispute settlement is flexible, and it's an adaptable field of law, and it is continuously adapting. It's adjusting to the evolving dynamics of foreign direct investment, new investment laws and policies, user demands, and to case experiences. This can in large be attributed to the flexibility of international arbitration, which really is embedded in the ICSID Convention and rules. But it can also be shown in the evolution of ICSID case law on both substantive and procedural matters. Now, two notable examples are SPP versus Egypt. That's the first case where jurisdiction was based on a domestic investment law. and AAPL versus Sri Lanka, the first case based on a BIT. Consent in writing to arbitration, as we all know, is a jurisdictional requirement under the ICSID Convention and a mandatory requirement. But as these early cases show, the convention offered enough flexibility to facilitate the consent requirement in these circumstances under these new instruments. Now, we may take for granted this consent model, where consent is based on a unilateral offer by the host state, which the investor then accepts. But at the time, the concept of arbitration without privity was quite controversial. And I don't know that most people would have predicted back in the 60s, when the convention entered into force, that there would be a shift to this model as the primary source of consent for ICSID arbitration. The second example, which concerns the procedure, is the development of the case law on transparency and non-disputing party participation. This followed one of the early calls for improving the ISDS system in the early 2000s, advocating for transparency in cases involving issues of public interest, such as environmental protection, public health, and human rights. Now, many tribunals have addressed the need for transparency, and at the same time, also the need to protect procedural integrity and the non-aggravation of the dispute in the context of unilateral publication of case document by a party. In 2006, in Bywater Gulf versus Tanzania, the tribunal emphasized the importance of transparency, particularly in the context of public, the legitimacy and accountability of the arbitration process, and said that it would be in favor of allowing publication of its decisions, its orders, and directions on a case-by-case basis. In particular, I highlight the tribunal statement that transparency and confidentiality have played different roles in commercial and investment arbitration. This is now the default rules under the 2022 ICSID rules. Orders and decisions are published with any redactions agreed by the parties, unless the parties agree otherwise. And almost 350 ICSID awards or extracts from them have been published, and many more decisions and orders. The Bywater and other decisions paved the way for another matter, the opportunity for non-disputing parties to file written submissions in cases. Even before ICSID introduced a provision specifically dealing with this in the 2006 rules, the matter was addressed in Suez versus Argentina in 2005. 5 NGOs filed a petition to participate as amicus curiae in the proceedings. And the tribunal reasoned that the case involved matters of public interest, namely the provision of basic public services to millions of people. It granted the NGOs an opportunity to apply for leave to file an amicus submission, and it later allowed them to file the submission, recognizing that the perspectives and expertise of civil society can assist tribunals in a determination of legal and factual issues before them. The 2022 ICSID rules now provide guidance on the consideration for allowing submissions, including that the tribunal must ensure that NDP participation does not disrupt the proceeding or unfairly prejudice a party. And this is really a development based on case law. A further important step in improving transparency was to allow non-parties to access hearings in person or by streaming. In 2004, the parties in Methanex versus the United States that was an ancestral case, but administered by ICSID, agreed to make the hearing open to the public. Members of the public were able to observe the hearing and in a live broadcast at the World Bank. So they had to fill in a form and fax it to ICSID. That was what we used to do 20 years ago. In 2010, in PACRIM versus El Salvador, that became the first case in which an ICSID hearing was webcast. And since then, many other hearings have been streamed to the public under either the provisions of a treaty or by party agreement. And the 2022 ICSID rules reflect this practice with a presumption in favor of public hearings, unless the one party objects. Now, these examples, they show how the system is adapting to stakeholder needs and demands. And we will continue to see that kind of adaptation, especially with regard to the procedure and new procedures. So for example, there is potential for greater use of mediation in ISDS, given the high settlement rate that we have seen in ICSID arbitration. We have already seen a few requests for mediation under our mediation rules, and this could be filed either before an arbitration or during an arbitration proceeding. And we have seen that ICSID's involvement at this stage has helped parties to put amicable settlement negotiations on new footing. And I'm optimistic that that is a trend that will continue. Now, ISDS is also adapting to the evolving case law, which leads me to my third observation. There is no binding precedent system in ISDS, but increased transparency has ensured arbitrators can consider interpretations of like treaty provisions in other cases, and they do so. In Saipan versus Bangladesh, the tribunal highlighted the need to develop harmonious case law and certainty of the rule of law. It indicated it would adopt solutions in prior case law if it was consistent, unless there were compelling contrary grounds. Now, it is debated whether consistency, in fact, can be achieved with so many treaties, and whether that should be the aspiration of an arbitral tribunal. But we have seen that arbitrators invariably do consider ICSID case law, and we have seen the development of consistent approaches to an interpretation of a number of legal questions, many of them relating to the provisions of the ICSID Convention. Many of these questions were addressed early on, and it took time before the case law was shaped and led to the formulation of tests that are now often referred to and applied. So, for example, case law has shaped the development of tests concerning the existence of an investment, which is one of the jurisdictional requirements of the ICSID Convention, but is undefined in the convention. In Salini versus Morocco, the tribunal discussed the characteristics of an investment and formulated a four-pronged objective test. And this test was refined in joint mining versus Egypt with regard to one of the prongs, a contribution to the economic development of the host state, requiring that the contribution be significant. Many ICSID tribunals have adopted this test, although some criticize the requirement of a contribution to the host state's economy and dismissed it. Other tribunals have added requirements, for instance, the lawfulness of the investment, or at the other end of the spectrum, emphasized party autonomy for the parties to be able to define their investment for the purposes of the convention. Now, each of these succeeding cases represents an instance where a tribunal was able to look at preceding decisions for guidance as to how to approach the question of whether or not an investment had been made. And that is at the core of the system, that whether or not they agree, tribunals can look back to decisions like Salini for how and why the principles have evolved. Now, there's obvious difficulty that arises when the applicable law on which the jurisprudence is based is so varied. And this is the challenge that we are seeing with the interpretation of many different investment treaties in ICSID arbitration. One example of this are the series of cases beginning with Mafasini versus Spain that debate the question whether an MFN clause should be applied to import more favorable dispute resolution provisions in a different treaty, particularly where doing so will remedy a situation where the tribunal would otherwise not have jurisdiction. Now, whether a tribunal will find an MFN clause extends to a more favorable provisions of a dispute resolution clause in a different treaty will depend on the language of the treaty being considered. In Mafasini, the tribunal allowed the relevant MFN provision to avoid a requirement to exhaust local remedies by relying on a less stringent provision in the Spain-Chile bit. A good contrast is the MFN clause in the Turkey-Turkmenistan bit, which has been interpreted in Kilic versus Turkmenistan as not broad enough to extend to the dispute resolution provisions in a different bit. In Kilic, the tribunal considered Mafasini and similar cases and distinguished the language used in the treaties. But even when dealing with the same treaty provisions, it is also not a certainty that tribunals will interpret it in the same way. An example of this is the way that Article 7.2 of that Turkey-Turkmenistan bit was interpreted by 3 different tribunals. The question was to determine whether that provision imposed a mandatory precondition to exhaust local remedies prior to commencing an arbitration. It involved difficult analysis of 3 different language versions of the same treaty, which were all equally authentic. The tribunals in Kilic, Muhammed Chap and İçkale came to different conclusions. The majority in Kilic decided that the provision provided for the mandatory submission of disputes to local courts and declined jurisdiction. The tribunal in Muhammed Chap found that the submission of disputes to local courts was optional under that provision. And in İçkale, the majority held that disputes did need to be submitted to local courts, but did not affect the tribunal's jurisdiction. They were procedural in nature. Now, in an ideal world, there should be consistency and predictability in the interpretation of the provisions of the same treaty. But these cases show the difficult task that tribunals are faced with concerning the treaty language. It highlights the need for clear treaty drafting to ensure greater coherence. And it also shows the constraints on achieving consistency across the many similar but differently worded treaties, as the decision makers will still need to interpret the treaty before them. And this would also be the case of a multilateral investment court or an appellate body. The judges would inevitably deal with similar provisions in different treaties and may reach different conclusions based on the circumstances of the case and the differences in those treaty provisions. They may also have different opinions on the same treaty, as we've seen in ICSID cases, but as we also have seen with judges in other disciplines. The reality is that the cases involve complex issues of fact and law, and that generate conflict in views. This leads me to my next remark, as I often hear that cases are getting increasingly complex. This is often argued to justify extensive preparation time, sometimes 6 months or more for briefs that exceed 500 pages and have thousands of exhibits. But I submit that it's not the cases themselves that are becoming more complex, but rather the procedural practices, which have adversely impacted the time and cost of proceedings. Generally, the longer the duration, the higher the costs. And that poses a significant obstacle to access to justice. And it's impacting especially small and medium-sized enterprises and states with limited resources. With the evolving landscape of cases, we may expect new complex subject matters of disputes. And the question is, how do we provide a framework which will allow for improved procedural efficiency to address these complexities? Procedural innovations are key in this respect. For example, the summary procedure that ICSID introduced in its 2006 rules allows for the early dismissal of claims that manifestly lack legal merit, known as the 41-5 objection in our old rules, and has since been further clarified in the 2022 ICSID rules, also as Rule 41. The first case to invoke this procedure was Transglobal versus Jordan, which was registered in 2007. And since then, this procedure has been invoked in almost 50 times, leading to the dismissal of all or some claims in at least a dozen cases. In some cases, the procedure has helped parties to avoid spending unnecessary resources when a claim is dismissed early in the process. Now, improving efficiency was one of the main objectives of the 2022 ICSID rules. And you see provisions throughout the rules that address this, such as the use of expedited arbitration and time limits for issuing decisions and awards by arbitrators. But rules alone are not sufficient to address time and cost. If we are serious about reducing time and cost, we need parties and arbitrators to use the tools at their disposal. We need implementation of best practices, and we need a change in the approach and culture. We at ICSID are committed to playing our part in this endeavor, and we will be rolling out several initiatives. And this will include arbitrator workshops, tracking the time it takes for arbitrators to issue all decisions and awards under the 2022 ICSID rules, and in investing in advanced technology for case management. Now, my final remark is that ISDS attracts public attention, and some cases have had a significant impact on public opinion towards ISDS. Often it has been the initiation of the case rather than the outcome that has caught public attention. Now, this is not always the situation. Some cases have been controversial for their award, in particular when there have been huge damage or exceptionally high damages awarded. But some of the most controversial ICSID cases from a public awareness and public policy perspective had unremarkable conclusions. So, for example, Philip Morris versus Uruguay, which involved restrictions on the marketing of tobacco products and was subject of media headlines. But less attention was given to the fact that a majority of the tribunal found Uruguay had a valid right to exercise its police powers to address a serious threat to public health. The claim was dismissed, and Philip Morris ordered to partially reimburse Uruguay's for its legal expenses. Another example, in 2012, ICSID registered the Swedish energy company Vattenfall's claim against Germany under the Energy Charter Treaty. It stands out as one of ICSID's most publicized cases, and made a major impression on the public in Germany and across Europe. The public criticism against investment treaty arbitration has had a major implication for policy in the EU. And this includes the backing of a permanent investment court as an alternative to investment arbitration. Now, did the Vattenfall case play a decisive role in the shift in EU policy? No. But I think it is hard to argue that it was not a factor. Yet the fact that the case was settled among the parties did not generate the same kind of attention that the initiation of the case received. Now, what are some of the takeaways from these examples? One is that a relatively small number of cases have had a significant impact on how the entire field is perceived by the public. And often that impact is not because of decision-making by our arbitrators, but rather how these cases have fed into and reinforced existing narratives about investment arbitration. Another is that losses by states tend to garner more media attention than wins, even though we know that investors and states have each succeeded in roughly half of the cases that conclude with an award. And finally, I would add that domestic media focuses more on cases against their country rather than cases initiated by their investors. And together, I would suggest that these factors have had a significant influence on how ICSID cases are viewed by civil society. And this is why it's so important to continually put forth facts and evidence about how the ISDS system is actually working. And this is only growing in importance as ISDS is further scrutinized. Now, we at ICSID intend to address these challenges through our robust outreach program and through our publications. And we will disseminate information and statistics about our cases to our stakeholders and the wider public. Now, what does this mean for ICSID's future? Looking back at ICSID's first 1,000 cases, I see a system that evolves quickly and adapts effectively, and that makes me optimistic. At ICSID, we have always viewed our role to ensure that our procedure is fit for purpose, and we strive to identify user needs and adapt to changing demands and circumstances, and we will continue to do that. Since beginning my term as Secretary General, I've traveled to many regions and heard feedback from many ICSID users and stakeholders, and my colleagues have done so as well. And the observations that we have received have been both encouraging and insightful. We at ICSID, we recognize that effective and efficient dispute settlement is key to creating business environments that attract, that retain, and that expand foreign investment. And I want to reassure you that we will always work with this goal in mind. Now, let me give you a few ideas about our priorities. First, our main focus will be to ensure the effective operation of the 2022 ICSID rules and to deliver first-class services to our users. As mentioned, we'll put special emphasis on time and cost of proceedings through several initiatives, and we will leverage on advanced technology. Second, we will be raising awareness about ICSID's availability for investment contracts and promote the use of expedited arbitration in that context. We are conducting research about contract-based ICSID cases, and we're also part of an UNIDROIT working group on international investment contracts. And this will enhance understanding of these disputes based on contracts and how international investment contracts can be drafted for use and greater use in ISDS. Third, we will continue to actively participate in the reform discussions before UNCITRAL Working Group 3 and other fora. So for example, about the establishment of an appeals body. And we will provide states with information about our cases and our case experiences so that they can make an informed decision. Fourth, we will promote the use of mediation in ISDS to encourage amicable dispute settlement, as we see there is great potential in that. Fifth, we plan to increase our international presence in various regions to be closer to our users and member states, and to be able to provide more capacity building and engage with stakeholders in the region. So this means to set up physical offices within the World Bank Group offices worldwide. So stay tuned about that. And we have many other exciting projects in the pipeline, which you will hear about in due course. So in conclusion, I'm confident that ICSID will remain at the forefront on ISDS, effectively meeting user needs and contributing to a prosperous global investment environment. Thank you.
Thank you so much, Martina. I'm so pleased to hear such a positive speech because that has not been very often the case in the past couple of years.